Let's take you now to this interesting case. A recent groundbreaking Free State High Court ruling that husbands can take their wives' surnames has sparked widespread debate. Two couples challenged the constitutionality of Section 26 of the Registration of Births and Deaths Act due to alleged gender discrimination. They argued that the Act and regulations perpetuate gender norms set by patriarchy that entrenches gender inequality. We have roped in Amy Joy Bernard, attorney specialising in family law, to weigh in on this ruling. Amy, thank you so much for your time and good afternoon to you. Perhaps unpack your understanding then of this ruling, which has now sparked many a debate. What specific constitutional rights did the court find were being violated for the husbands in this matter, and perhaps its interpretation then of this Section 26 of the Act?
Hi, Nati. Thanks for having me on. So in this case, it's a very interesting case, and it's obviously a very recent case at the High Court. And the court did find that it was unconstitutional, and it was most likely on equality, that there's no equality in both people having their own names or surnames being the representative of their family. But it is a patriarchal thing where we see that women are always having to take men's name. And because it was in this act, it wasn't necessarily in the Marriage Act. It's in this act that gives the power to Home Affairs to do birth certificates, marriage certificates, and those kind of things, that this needed to be changed in order for us to see the change in practice. So you can see in this case, if one goes through the case, that they really struggled, the applicants in this matter, they really struggled to get anybody to listen to the fact that it isn't fair that a man can't take his wife's surname or hyphenate with his wife's surname so that their children have the same name.
I mean, there's so many aspects to unpack here. Could this ruling serve then as a precedent, for other cases involving married couples or family law changes? There's also, of course, surname choices to consider for children, perhaps. I would imagine that would also need to be considered.
Look, I think at this point, it's not going to have a direct influence on child naming at this point. I think this is more of a marital name for adults. But as somebody who does a lot of work with Home Affairs, I am also a wedding officiant, so I go and register marriages quite often. And I register marriages in terms of the Civil Union Act, which doesn't presume gender. So actually, in terms of the Civil Union Act, straight couples, so two members of opposite sex, can marry and can take it on whatever surname they'd like. So this is just an issue in terms of Marriage Act marriages.
I see. So just looking at the Section 26 of the Act in question, will it now need to be amended or reinterpreted in other cases?
It would definitely need to be amended. Also, the regulations are the main thing that would need to be amended, because that gives Home Affairs the power to actually make real world changes. Remember, when we've got when there's something that we say is unconstitutional and we go to court, the first port of call is to go to the High Court in your area and say, I think this is unconstitutional. What do you think? The court then says, I agree, it's unconstitutional, and it gets referred to the Constitutional Court, who then basically makes an endorsement to say either, yes, I agree, it is unconstitutional, or no, it's not unconstitutional. Once that's happened, they will have 24 months, meaning Parliament, to change the Act and the regulations so that Home Affairs can then register men under their wives' surnames or hyphenate men's surnames for them.
Just talk to us about then the broader implications of this ruling for gender equality. You mentioned equality quite strongly in the beginning. And of course, societal norms in the country, because we are now having this debate where some people are thinking that this ruling is not necessarily something that would serve them.
Well, it doesn't have to serve everybody. It just has to serve those who it's unfair to. And the truth is that if you do want to take your wife, if a wife wants to take her husband's name, she'd still be able to do that. That's her choice. But everyone should have a choice to make the family name and have the equality that they deserve. And I feel that having a surname, especially in South Africa and in our African context, it's a really big thing to carry a surname. And it has a lot of implications into the emotions of a person, and especially on what do they project to the world. So I think it is something that's really going to make a lot of change in the future. And I think it's a good step in the right direction for women's rights. And you know what? It is just equality. You can choose. If you don't like it, don't change your surname to your wife's surname.
Absolutely, I agree with you on that. Is there, Amy, any possibility of this decision being, for whatever reason, appealed or opposed? And what would the grounds be? I mean, if that were the case.
Look, at this point, I don't think it will be. It was an unopposed application. So the Minister of Home Affairs didn't come back and say, oh, I don't agree with this, or I don't want it to be made into law. They kind of left it open-ended. So it was unopposed. So no, I don't think there is a way that somebody could go to court now and say, no, we think that it should, this provision should stay in place, especially because it's, in my opinion, quite obviously unequitable.
Amy,
it's not a...
No, absolutely. Thank you so much, Amy, for engaging us on this one, and thank you so much for your time. Amy Bernard, the attorney specialising in family law, to weigh in on this groundbreaking ruling from the Free State High Court, ruling that husbands can now take their wives' surnames. It has, of course, sparked some form of debate.